So I am objecting to the tactics of the Fulton County District Attorney's Office and whomever else they may have employed with a citizen, regardless of what the court may think of him, what the prosecutor thinks.
I don't have any thoughts. So please don't put that in. Please don't put that in the ether. Okay, but that's what you just said, sir.
Ether is
okay.
Clear. The court wouldn't do it. I wouldn't do it either. So why is it happening?
I have no interest other than I'm a referee.
Well, you're the referee who spoke with the witness without my presence.
Mr. Steele, we're not gonna get it.
Stop it right there now.
Did you know about Lucci's mother's home being shot at?
What you mean?
Were you aware that Lucci's mother's home was shot at?
Huh?
A few moments later.
During the interview, were you able to give Mr. Investigator Thorpe your date of birth?
Huh?
Welcome back to the AV to the 7th Power channel, where we talk about all things law, crime, and a little bit of debauchery. Are you guys ready to talk about the dumpster fire that has become the YSL trial? This is your recap for the week. And before we go anywhere, please check out the sponsor of today's video, Aura. If you want to protect your data, your privacy, your credit, and stop robocalls, please check them out. You have a free 14-day trial using my code below. Let's get into it. On Monday, the trial began with a dramatic turn when Young Thug's attorney, Brian Steele, was held in contempt of court. This decision by Chief Judge Glanville stirred up quite a controversy, with Steele facing the possibility of jail time. People in the legal community were outraged. To navigate this legal turmoil, Ashley Merchant from the Georgia Association of Criminal Defense Lawyers, GACDL, stepped in to defend Steele and quickly filed an appeal. GACDL's strike force, a group of attorneys, also showed up to the courthouse in support of Steele. 25 of them were not allowed in the courtroom.
I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you.
What?
And then somehow that email was CC'd to me. That never.
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it? I'm
going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. It's those were ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said.
And you haven't answered my question yet.
How did you answer that question?
You're not.
No, I will not answer that
Why
question.
will you not answer that question?
Because I want to make
Ooh.
sure that what I say is accurate, and I'm not trying to
No,
get
no, no,
anybody
no.
else
I'm
into
asking you,
any-
how did you get this
I'm
information?
not telling the court. What I'm saying is based on information.
Oh.
How you got this information, then you and I are going to have some problems.
We can have this. I have problems right now. and
Okay,
I'd like to
I know.
continue.
Look, I don't want to know about your problems. Okay, at this point in time,
Wow.
all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
A party,
yes.
a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court
Mr. Steele,
handed
ask
Mr.
me.
Copeland.
Tell me how you
perjury.
got. Tell me how you got the information.
Listen, whatever you want to do.
Tell me
I'm
how
not
you
telling
got the information. Then we can go ahead and go forward.
I'm not going to say that, but I'm going
Well,
Do y'all see the conflict? The judge wants the name.
Right.
The judge says, tell me the name. Who told you? We can talk about anything you want afterwards, but tell me the name. Brian Steele says, I'm not going to tell you the name. Right? So this is the major conflict going on right now. Let's go.
say is this. I was told, and I hope this concerns the court.
it
I was
concerns
told-
me that you have proprietary information
Why is it
or
proprietary?
information that you should not be having that was ex parte
Why?
with a party,
Why?
state of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly
That's
this honorable court,
okay.
or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is
Oh my
coerced.
God. So he has actual word for word. He has actual word for word testimony of what was said in these secret meetings. Let's go.
Wow.
He announced he's not testifying and he'll sit for 2 years, and then supposedly
That's
this honorable court,
okay.
or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele,
I'm
I
doing
still
what
want to
everybody
know,
should
how did you come upon this information? Who told you?
What I want
told
to know
you?
is, why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who.
Uh-oh.
I'm not- I
Tell me who this information
don't
was
want to
come
be
from.
held in contempt.
Well,
I'm not
then-
answering that question. That's attorney-client privilege information. I am not answering that.
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you what, I'm going to give you 5 minutes. If you don't tell me
You don't
who,
have to. I'm
if
gonna
you don't tell me who it is, I'm going to put you.
Well, let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you
telling
how did you get that information
I don't
supposedly
answer
from
that
my
question.
chambers?
Hmm.
Did somebody tell you?
I'm not. You should have told me.
Oh,
You got 5 minutes.
Well,
Oh.
yeah,
Oh my God.
this is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
what?
And I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's.
Ashley Merchant is who is Ashley Merchant? Who is Ashley Merchant? Now we all know who Ashley Merchant is. She is who does she represent in the Fani Willis thing?
She represented Michael Roman, the one that set in motion all of this.
Yes, but what you guys don't know is that Ashley Merchant is the president of GACTL, and she is representing Brian Steele. Brian Steele he's pretty much for right now the #1 criminal defense attorney in the state of Georgia, and he is being represented by Ashley Merchant. Oh man, this is going down. Let's go. This is getting good.
Ashley Merchant. Yeah, Ashley Merchant.
Oh, it's going down in the courtroom.
All right.
There
I
she
have told
is.
your client, you represent Mr. Steele, is that correct? Yes. For the purposes of the contempt, I've entered the order. I've entered the contempt already.
Wow.
I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know who told him that.
Who told you?
So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no supersedeas bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is, because of the way this information was disclosed, it is troubling to the court and is very.
And again, guys, for the new people coming in, what are we talking about? The judge was having secret meetings with the prosecutors. This is called ex parte communication. This is not allowed. And somehow these meetings got back to Brian Steele, who represents Young Thug. Brian Steele is pretty much the #1 criminal defense attorney in the state of Georgia. And he chastised the court and asked for a mistrial based on these secret communications. The judge said, forget all this secret communication stuff. Who told you? I want the name. And Brian Steele says, well, who cares who told me? You guys are having secret meetings. I was not available. I was not allowed. I was not invited. None of the defense counsel was invited. All of these defense attorneys were locked out of these secret meetings. And he wants to know, Brian Steele wants to know what the hell was going on in there and why are you having these secret meetings? The judge is like, I don't care about the secret meetings. Who told you? The judge put him in jail. The prosecutor was like, Judge, you got to let him out of jail because, well, I say jail. I'm talking about the holding tank in the courtroom. The prosecutor said, if you don't let Brian Steele out to finish this trial, it's going to be a mess. So the judge let him out to finish the day. And the judge said, at the end of the day, if you haven't told me, you're going back into the holding cell and then you're going to jail. It is the end of the day now. It's about 6:08 in Atlanta. And the judge is saying, listen, secret meetings or not, you got to tell me who told you. Apparently the hallway in the courtroom is attached to a hallway. And outside the hallway, there are tons of attorneys protesting what the judge is doing, including Gactel, which is the #1 criminal defense attorney association in the state. Ashley Merchant is the president of Gactel, and she has been retained by Brian Steele to represent her. So she is in the courtroom now, and the judge says, hey, listen, tell me the name. If you don't tell me the name, you're going to jail until you tell me the name. I'm going to let you out as soon as you tell me who told you about my secret meetings. Let's go.
I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
and Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different.
And notice the judge said, you know, he knows too many details. He knows too many details of what was being said in these meetings. You know, it wasn't generalized. He knows specifics. How does he know who told you what about my secret meetings with the prosecutors against your client?
So these are Fani prosecutors too. Like that woman, Miss Love, is right there at the other side. She works for Fani Willis. So the fact that this is coming full circle.
Great point. This is a great point. Yes, all these people, the two black women and on the left, I guess on the bottom of the screen, and the white man, these are the prosecutors prosecuting Young Thug. They have all been hand selected by Fani Willis. And now, as AV said, you have Ashley Merchant, who was kicking Fani Willis's butt up and down the street in the courtroom. So we have a family, a Fani Willis family reunion in Judge Glanville's courtroom. So let's go.
Ms. Merchant, I won't disagree with you, but
Well, and
Okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law. that
Go,
says that, Ms.
Yes,
Merchant,
it is
'cause I- 'cause-
Henry McClarty.
Oh, she got the case.
He was ready.
Case. Ashley is teaching. I don't want to say she's teaching Judge Glanville about criminal contempt. And this is messed up, guys, because Glanville, listen, I got a lot of respect for this man. And this case has really been a shit show. And we'll talk about all that. Judge Glanville, she's our chief judge. This man is the man. And Ashley Merchant is like, no, you held him in criminal contempt. You're doing it wrong. There is a procedure. And the judge is like, I don't believe you. Tell me the case. And Ashley's like, well, here's the case, right? So let's go. This is getting deep, man.
As we just saw on the clip, Ashley Merchant argued beautifully and talked about the differences between contempt. There's civil contempt and there's criminal contempt. Civil contempt is the failure to obey a court order that was issued for another party's benefit. A civil contempt proceeding is coercive and remedial in nature. Criminal contempt, on the other hand, is an act that obstructs justice or attacks the integrity of a court. A criminal contempt proceeding is punitive in nature. On Tuesday, the witness known as Woody began his shenanigans. Woody was present at the controversial ex parte meeting. He fired his attorney who attended the meeting. The judge released her but mandated her to attend an order to show cause meeting scheduled for June 25th.
Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She fat.
She's fired? Okay. So do you wish to represent yourself in these particular, in terms of any issues you may have in this particular?
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
You can keep your lawyer that you have right
I
now.
don't want her.
All right. You could certainly hire another lawyer, or the court could appoint you a lawyer.
How you gonna do that, buddy?
Do what I need a lawyer for?
Huh?
What
No,
do I-
it's just.
Don't
the
do
court
it.
Is just asking you whether it's your choice, sir.
I'm good.
You're
Don't
good?
represent
Ms.
yourself.
Gomez, did you file an entry of appearance? All right. Did you, under the Uniform Superior Court rules, file a motion to withdraw pursuant to the Uniform Superior Court rules? I mean, I know you give an oral notice, but usually that's to be in writing, and he has 10 days to object. Say again.
I was never his counsel. Attorney Melnick was his counsel, and I was stepping in as a courtesy for judicial efficiency. But if the court's desire for me to file a motion to withdraw,
Oh my God.
Well, given the fact that you have represented Mr. Copeland at this point in time, it would seem appropriate that you do need to, in fact, file a formal withdrawal. Even though you didn't enter one, you de facto entered this case by your representation of him, or you telling the court that you did, in fact, represent him. So at this point, I'm not inclined to release you until that's done.
I'll get that done now, Judge.
Okay, all right. And he's got 10 days to go ahead and do that. So you're still going to have to be here until because he gets that particular period of time to go ahead and decide whether or not he'd like to hire a lawyer. That's the whole reason for the 10 days.
Well, I don't want to hire no.
Hold on.
Why does he get a
Not yet.
free lawyer though?
You get that right
Witness.
as a party.
I
Okay.
do get right.
You do, yes. You get that right to hire a new lawyer. You get the right to do a couple things. One, to decide whether or not you will release her.
Okay.
Okay. Two, you got to decide whether or not you want to get another lawyer to be with you.
Okay.
Okay, those are the two big things you get a chance to kind of decide. But what I'm going to do at this point in time is, since she's representing you, I'm going to make her file a formal notice to withdraw. She's orally told you at this point in time she wants to withdraw, but you're on the stand, you're testifying at this point in time. So I'm not going to let her withdraw at this point.
Well, Your Honor, I just like to say, before he started testifying, I was fired.
I don't know that, ma'am. That's not something that I have notice or knowledge of. So,
Oh no.
you know, that's the whole purpose of the rule, so that we can flesh out all those things. So at this point in time, I'm not inclined to let you go at this point. I'm sorry that you put yourself in this particular situation with you and Mr. Melnick and whatever, but, you know, Mr. Copeland does have rights in this particular circumstance. So file a proper notice to withdraw. I'll give once it's filed, if you file it today, I'll give Mr. Copeland the 10 days, but until such time as I rule upon that and he gets that and gets an opportunity to think about what he'd like to do, I'll go ahead and insist that you remain with us while he's on the stand.
Okay, Judge.
Okay.
That's a really messed up
Madam, I
ruling.
have one other bit of business that,
Also, can we approach? Can I approach, Your Honor, with the state?
no.
Wow. Wow.
What does he want to tell me?
I don't want to say it in open court.
It's about the meeting. It's about the meeting.
It could be about the meeting. AB could be exactly right. Well, I don't know. Yeah, I mean, it absolutely could be. I don't know if this is the attorney that was at the meeting, because
Yes, this is.
she said that she was covering for somebody else, though. She said that she was there as a courtesy. Isn't that what she said in the beginning?
Yeah, but a while ago. She was there.
Or was she the one at the meeting?
Yeah. I think
Dang.
this is who Brian was protecting, because she's standing in for someone else.
It's
Look at
going
his
down.
look at his body language.
Yeah. Look at
It
the
was
judge
her.
thinking.
It was her. I'm calling it. It was her.
All right, state Ms.
AB is calling it. AB's calling it like, hey, man.
Now he's letting them approach. Two opposing sides, defense and prosecution. Only these two people were in that room. Not only these two people were in that room yesterday.
Yes. And the judge really, I don't think the judge is following the law.
And I don't believe you have the right to be present, sir.
If I try to fire a client, oh, AB, you could be exactly right, because they're not allowing the defense counsel up there.
I knew it. I knew it. I knew it. Shout out to
And
me.
I don't believe you have the right to be present, sir.
Ooh.
State objection for record. I do think we have the right to be present, and I think there's case law to that effect. I want to object on the grounds that we are now being excluded from a conversation.
Yep.
Thanks.
Yep. Better object.
And prosecution of the state versus the non-dependents and material witness, conversation about material witness, and a conversation between the court and that counsel for that witness and the state, which are now conducting a meeting with the court without the ability for me as the attorney for the defense in our case to be present and knowledgeable about those conversations. And I think that that ex parte communication creates an appearance.
Of impropriety.
I say this with tremendous reservation, and I almost want to apologize for saying it.
Yeah.
I think it creates appearance of impropriety and bias on the part of this court. I don't mean to suggest Your Honor is doing that, but it creates the appearance of it. So I have to check. Okay.
This is another secret meeting.
And I'll adopt everything that's now said, but I'd like to just add also.
Go, Brian.
12 with the Constitution, also denies Mr. Williams that
Wow.
Sorry, Your Honor, if I could just add to that for the record. I'm going to cite to the Uniform Security Court Rule 4.1.
Ooh, they're going on ethics.
Prohibits this type of communication. I'll cite to the Georgia Code of Judicial Conduct, Rule 4.4.
Yep.
Prohibits this type of communication.
Wow.
I'll cite to the court several cases which I can support that. First is Monday versus Magnolia Advanced Materials, which is 815 Southeast 2nd 70.
The attorney is citing cases.
He had it ready.
Know why the judge is not allowed to do this under case law and under
He just got
statute.
caught. He just got caught. I have model rules of professional ethics up.
Yeah.
2.9.
1976 case.
Oh my God.
Not attempt to intimidate witnesses testify on behalf of the state either in or out of the presence of the jury. And it also creates a presumption that the court should have to recuse itself. That case is Hargis versus State, and that's 319 Georgia Act 432.
He just said the court should recuse itself because of the appearance of bias. Oh, these attorneys are getting in this judge's ass for this secret meeting.
It's exactly what it looks like. You let them up. So that proves that it was her.
Wow, the judge said
Your Honor,
fuck
I
the
just
meeting.
wanted to be given an opportunity to be able to respond to that on
The
the
judge
record
said fuck the meeting.
and to point out that
Wow.
the distinction between the assertions by counsel for the defendants and what is going on here, and the assertion being made that a trial judge should not intimidate or coerce a witness. Actually, can we?
Yeah, hold on a second. Mr. Can I get you to step outside for just a second? Let me finish this argument, please, sir. Mr. Copeland?
Where, you want me to go out?
Yeah, just step outside in the vestibule if you wouldn't mind, sir, please. Thank you.
The judge doesn't even want the judge doesn't want him to hear it. He could be the mole.
Oh my God. Well,
he could be the mole.
He fired his lawyer this morning.
Yes. Y'all see little Woody's face?
Wow.
Y'all remember y'all used to cough in 2020, 2021, it was that COVID. Look at Woody's face when the judge called. It's a COVID.
Are you able to see who's in 3738? Yankee, 164 Echo Hotel, and 164 Echo.
Get back.
Oh my word.
He about to pull the code. Look, she running too. Black women will run. Wow. Says the court having been presented with an issue of contempt for determination. All individuals that were present for the secret meeting that took place in the court's chambers on the morning of June 10th, just yesterday, specifically to include the witness, Mr. Keith Copeland, AKA Lil Woody, his attorney, Miss Kyla Bumpus, and all representatives of the state and court security personnel that were in attendance are hereby ordered to show cause before the Honorable Chief Judge Glanville on the 25th day of June 2024, 9 a.m. courtroom 1C, 185 Central Ave, Atlanta, Georgia. Why one or more of them should not be held in contempt for disclosing the information from the secret meeting to members of the defense counsel. Oh my God.
He's going to put them all in contempt
Oh
if
my
if
God.
they don't snitch on who the rat was.
Oh my God. He wants a name. He sentenced Brian Steele to the max, 20 days incarcerated.
He is Wildin'.
He couldn't get a name. Now he's getting all of the people in the secret meeting together. Guys, is this not messed up? What about Jeffery Williams? This has nothing to do with Young Thug. He wants to find out who the mole is. And he says it's to find out why one or more of all of them should not be held in contempt for disclosing the information. It is further ordered that the failure of any individuals who were present for the June 10th secret meeting will cause the court to direct the Fulton County Sheriff's Office to take them into custody immediately and bring them to the bar of this court. So if they don't show up, the sheriff's office is going to find them and bring them to court.
That's why he was smooth for the rest of the day. Y'all notice that he was quiet?
Yes, this is crazy, guys. Signed the Honorable Glanville Chief Judge. Man, he is gonna, y'all thought it was over. That's what the judge said. Y'all thought it was over. Y'all thought he won. Y'all thought Brian won. Y'all thought I wasn't gonna get a name, didn't you?
Wednesday, of course, we saw more Woody shenanigans. In fact, Woody was such a difficult witness. Individuals in the courtroom saw the prosecutor questioning him, Christina Hilton, crying during breaks.
I don't know.
You have hair on your head when you take the picture?
What you
When you
trying
took
to
the picture?
He's like, what you trying to say? Did y'all see his face?
Oh my God.
You're like, what are y'all saying? Lee, did you have hair on your head when you did it? What you trying to say? Did y'all see that? Hold on, we gotta rewind that. He was about to get up. What? He was about to start throwing hands. Like, watch his expression, guys.
Yeah.
He took offense. He took that personally. Watch his face. Hell no. Let's go.
How old were you all when you took this picture?
I don't know.
You have hair on your head when you take the picture?
What you
When
trying
you
to
took the picture?
What you trying to say?
It look like I got hair on my head.
How long
Oh my God. I'm trying to keep it in. Count to 10, Woody. Count to 10. What you trying
When
to?
I got out of prison.
Okay. So this is before you went into prison.
It's an old picture.
And that's what I need to know. Thank you very much.
Tensions escalated as the defense attorneys filed a motion for Judge Glanville to recuse himself from the case, which was denied. In a significant development, the Supreme Court of Georgia granted Brian Steele a supersedis bond, preventing him from being jailed. The appeal has been stayed until the conclusion of the trial.
What are we looking at? It says in the Superior Court of Fulton County, state of Georgia, the courthouse is right down the street. State of Georgia versus Diamante Kendrick. Motion to recuse Chief Judge Earl Glanville. Oh my God. They're trying to get him off of the case. Why? What did he do? Let's take a look at it. He says the defendant, Mr. Diamante Kendrick, by and through undersigned counsel without waiving any rights, files this motion to recuse Chief Judge Glanville from continuing to preside over the present case and request that the present trial be temporarily halted until the present motion is heard by another judge of this superior court consistent with the uniform rules. It is vital to the functioning of the courts that the public believe in the absolute integrity and impartiality of its judges. And judicial recusal serves as the linchpin for the underlying proposition that a court should be fair and impartial. The present case involves a 65 count racketeer influence and corrupt organization indictment against 28 individuals. Jury selection in this case began in January of 2023.
Wow.
Guys, 2023 is when this case started. And with the jury trial beginning in November 2023, given that the state has presented less than half of its current witness list, which the state has announced would be increasing based on circumstances, this trial should last well into the year 2025. The 6 defendants presently on trial, including Mr. Kendrick, have been denied a bond and incarcerated for over 2 years. The central figure, perhaps a central figure, perhaps the central figure in the state's case is Kenneth Copeland, aka Lil Woody. He's the star witness, guys. On Friday, June 7th, last week, Lil Woody was sworn in. Despite being, can y'all see that? Hold on, let me see if I can make it.
Yeah, zoom a little bit. Mm-hmm.
Is that a little bit better? Squeeze it in there.
Yes, that's good. Feed it in.
Right? Despite being warned by Chief Judge Glanville that incarceration may be the result of refusing to testify after being given a grant of immunity, Lil Woody refused to testify on that day. Lil Woody was ordered incarcerated by Chief Judge Glanville. And Chief Judge Glanville instructed Lil Woody and all parties that Lil Woody would be returned to court on Monday, this past Monday, guys, where Lil Woody would announce whether he was prepared to testify. On Monday, all defense counsel were present in the Fulton County Courthouse around 8:30, admitted entrance into courtroom 1C, and seated within by 9 a.m. Defense counsel waited and waited and waited. Between 11 a.m. and 11:30, Chief Judge Glanville took the bench and announced that Copeland was prepared to testify. So the judge told everybody that the court was going to start at 9. Everybody was waiting at 9 for hours. The judge didn't start the case until 11. Attorney Brian Steele, counsel for defendant Young Thug, inquired with the court as to the delay and what had occurred prior to Chief Judge Glanville taking the bench. His inquiry was not accepted. And guys, what was happening during those 2 hours? What was happening? The secret meeting that happened on Monday. The secret meeting. All the judges were in, all the attorneys were waiting in the courtroom. The judge was in a secret meeting with Lil Woody, Lil Woody's attorney, the state, the prosecution, and they were trying to force Lil Woody to testify. Unknown to any member of defense counsel during the waiting period in the morning, upon information and belief, a secret meeting was held in Chief Judge Glanville's chambers on that Monday, June 10th. The meeting comprised of Glanville, the judge, Assistant District Attorney Love, Assistant District Attorney Hilton, other members of the Fulton County District Attorney's Office, deputies, sworn witness Lil Woody, and Lil Woody's attorney, Miss Bumpkus. No members of the defense counsel was present at the secret meeting, despite the subject matter of the meeting being a critical phase of the trial. Upon information and belief, neither Chief Judge Glanville nor any member of the court staff nor the Fulton County District Attorney's Office made any member of defense counsel aware of the secret meeting. either before the secret meeting was held, during the secret meeting, or after the secret meeting. Little Woody briefly testified prior to a lunch recess. One or more members of defense counsel were later made aware of the secret meeting with sworn witness Little Woody and made aware of at least some of the content and subject matter of the secret meeting. Upon information and belief, the following events occurred at the secret meeting with sworn witness Little Woody in the judge's chambers. All right, let's see.
Here we go.
Have been said. The sum and substance of the secret meeting. Are y'all ready? Let's take a look. Upon information and belief, Little Woody announced that he would invoke his Fifth Amendment rights and not testify. Upon information and belief, Little Woody stated that he would sit in jail for 2 years rather than testify against Young Thug. Chief Judge Glanville informed Little Woody that the judge would keep sworn witness Little Woody incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. This is crazy, guys. Listen, so many defendants right now in the courtroom, there's 6 defendants, but there are other defendants to this case as well. They have just been separated. Their case has been severed. So they are kind of waiting on this case to shake out. The judges said, Lil Woody, if you don't testify, not only am I going to keep you in jail until the end of this trial, which is expected to take until 2025. But once the 6 people in this courtroom are done, we're going to bring some more people in, and you are going to sit until those people's trials are done.
Oh my gosh. That is coercion.
Yes, absolutely, AV. You are exactly right. That is coercion. That is witness intimidation, and it is being done by the judge. Can you believe the judge is trying to force the state's key witness to testify against Young Thug? What if you found out that you were on trial and the judge is trying to force somebody to testify against you? This is outrageous. Upon information and belief, after the judge told Little Woody that he would keep Little Woody in jail, incarcerated until the other defendants were tried, Assistant District Attorney Love or Hilton informed Little Woody that there were over a dozen defendants left to try.
That's
Guys,
why he's mad.
Yes, they could have had Little Woody sitting in jail 2027, 2028. Who knows how long all of these people are going to take? All because Little Woody doesn't want to testify. Do y'all see them threatening Little Woody? Upon information and belief, following the above coercive actions by Judge Glanville in conjunction with one or more attorneys from the DA's office, sworn witness Lil Woody stated at the secret meeting that he would testify. Oh my God. Oh my, they broke him. They broke him. Little Woody said, I'm not going to testify. Put 2 years on me. The judge is like, 2 years? Oh, 2 years? That's not enough. That's not enough. After this case gets resolved, which might take 2 years, we're going to bring some more defendants. And then the prosecutor was like, yeah, we got 12 more defendants. This is going to take years off your life. You can testify right now, Woody. Woody, piensa, think. We're in the courtroom already. Well, you're in my chambers. We're in the courthouse. The jury is here. The attorneys are here. Why do you want to spend 4 years of your life in jail? Why do you want to spend 4, 5, 6 years of your life incarcerated? Just testify, Woody. That's all you got to do.
That's so bad for a judge
It's
to do.
sickening. Sickening. So they're all ganging up on him. The judge is saying, I'm sorry, this is aggravating me. The judge is saying, Woody, just testify, man. You're already right here. Don't spend 4 years of your life incarcerated. The DA's office, just testify. What did Woody say in the end? I'll testify. Oh my God. Woody said they broke him. He did not want to testify against Young Thug. They threatened him with multiple years of incarceration. And the judge is doing this. The judge is doing this. This is insanity. Upon information and belief, Chief Judge Glanville also presented sworn witness Little Woody with a printout of the perjury statute and wow, they got the details of this. Wow. The judge presented Woody with a printout of the perjury statute and the false statement statute in the secret meeting. Little Woody stated to ADA Hilton that if called to testify, he would simply lie on the stand. In response to Little Woody's statement that he would lie, ADA Hilton said that she would not prosecute sworn witness Little Woody if he were to lie on the stand. Wow.
Wow.
So Little Woody says, okay, y'all want me to testify? Fine, I'm a lie. What's the problem with lying, guys, when you're sworn in as a witness? There's a word for it. What's it called when you lie on the stand? It starts with a P, right? Perjury. It's a crime. Don't you know the ADA looked at Lil Woody and said, if you commit a crime, we ain't gonna prosecute you. We ain't gonna prosecute you. Just do the best you can. And all this is said in the judge's chambers. Imagine a prosecutor whose sole job is to prosecute saying, no, we're not going to prosecute you on this one. Just testify for us. Upon information and belief, Little Woody also stated to ADA Hilton, and again, guys, ADA Hilton, that's the Black woman who was crying. ADA Hilton is the one who's been direct examining Woody all day long. And Woody was getting the best of her. And shout out to Infamous Sylvia, who was in the courtroom. Infamous Sylvia said that she saw Attorney Hilton break down crying because she couldn't get Little Woody to say what she wanted to say. And she got overwhelmed. The whole world is watching. And this woman, Hilton, she's an attorney. She's smart. She passed the bar. She has a law degree. Little Woody might not even have a GED. And Little Woody is getting the best of her. How embarrassing. Oh, ADA Hilton told Little Woody that she's not going to prosecute him if he lies. Little Woody also told ADA Hilton, the woman that broke down crying today, that he would testify that he killed Donovan Thomas Jr. Who is this peanut? So the whole thing, they want Donovan, there's a guy called Donovan, AKA Nut. They want to pin Nut's murder on Young Thug. Little Woody was like, if y'all want me to testify, I'll say I did it. I did it. And he said he would do it in front of the judge and in front of the prosecution. No one told the defense attorneys. No one.
That's terrible. This is so corrupt.
This is so bad. Upon information and belief, in response to Little Woody's stating to Attorney Hilton that he would testify that he killed Nut, Hilton told Little Woody that she would prosecute him for perjury if he testified that he killed Thomas. Wait a minute. First, this attorney who broke down crying said that she would not prosecute Little Woody if he were to lie on the stand. But when little
Wow.
Woody said that he would lie on the stand about the murder of Nutt, then ADA Hilton was like, oh, we're going to prosecute you for that. We're going to prosecute you for that. We need this murder to be on Young Thug. We don't need this murder to be on you. You can lie about whatever you want, but you better not lie about this murder. This murder belongs to Young Thug. And if you get up there, and I'm going to ask you, if you get up there and you say that you murdered Nutt, we are going to prosecute you. What happened today? ADA Hilton got up there and said, Lil Woody, you know Nutt was murdered. Yeah. Little Woody, did you murder Nutt? I don't think I did. I don't think I did. That's what he said. That doesn't seem like that's something I would do. Do y'all see the pressure that this man has been put on in front of the judge, in the judge's office? This is outrageous. Upon information and belief. Oh, so all right, we already did that. So, okay. So during court on the afternoon of June 10th, 2 days ago, when one or more of the above allegations were presented to the court by Attorney Steele, Judge Glanville denied that one or more events above relayed to him were accurate. The judge must cease to act and must make an immediate determination. When a trial judge is presented with a recusal motion and an accompanying affidavit, 1, 2, 3, 4 words with an A, the judge must temporarily cease to act on the merits of the case and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case. The present motion for recusal is being timely submitted to the court. This motion being filed and presented to the court in a timely manner, Uniform Superior Court Rule 25 governs recusals. Motions to recuse, along with accompanying affidavits, are required to be submitted to the presiding judge no later than 5 days after the affiant learns of the alleged grounds of disqualification. What is this saying right here? This is saying right here, guys, that when you find out that the judge fucked up, you only have 5 days to submit a motion for the judge to get kicked off the case. You can't wait 2 months or 3 months. You have 5 days. Such submission shall be submitted no later than 10 days prior to the hearing or trial, which is the subject of recusal, unless good cause is shown for failure to meet the time requirements. Given that the most recent incident demanding recusal just occurred on June 10th, a 2-day period elapsing from the incident requiring recusal to the filing of the present motion is good cause. So they're saying right here, we only waited 2 days. So we're in here. So this motion is not late. This motion is timely filed. What's next? The present motion includes a sufficient affidavit demonstrating the need for recusal. An accompanying affidavit by Douglas Weinstein, who is one of the attorneys, with evidence for recusal has been filed and is now presented which fully asserts facts upon which this motion is founded. A review of the Weinstein affidavit shows that it clearly states facts and reasons for the belief that bias or prejudice exists. The Weinstein affidavit is specific with respect to time, place, persons, and circumstances which demonstrate bias in favor of the state that prevents impartiality in the present case. The particulars of the Weinstein affidavit are provided above and need not be presented again here in detail, but lays out alleged actions of Glanville, the chief judge, in conjunction with the state with respect to Little Woody in the secret meeting. Recusal is warranted based on the facts alleged in the Weinstein affidavit. The facts alleged in the Weinstein affidavit must be assumed to be true when deciding whether recusal would be warranted. The details learned by Weinstein detail the holding of an improper secret meeting conducted with Little Woody, which violated the constitutional and statutory rights of Kendrick, including the right to due process and a fair trial. The secret meeting with Little Woody was in violation of at least Section 2.9 of the Georgia Code of Judicial Conduct. What is that? What is the Georgia Code of Judicial Conduct? Let's see what it says. Assuring fair hearings and averting ex parte communications provides. Let's go down to 3. Judges shall accord to every person who has a legal interest in a proceeding the right to be heard according to law. Judges shall not initiate, permit, or consider secret meetings. This is crazy. This is the law, guys. This is so insane. Let's keep going. Judicial conduct, which assures every person, including persons such as Mr. Kendrick, of a fair trial. Ex parte secret meeting communications are presumed to have been in error. Rule 211 in the revised Georgia Code says generally that judges shall disqualify themselves in any proceeding in which their impartiality may be reasonably questioned, followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one. The facts must be considered from the perspective of a reasonable person rather than from the perspective of interested parties or their lawyers, or from the subjective perspective of the judge.
Wow.
What are they saying here? They're saying, listen, guys, listen. In order for a judge to be recused, you have to use a reasonable person standard to see if there's any type of bias, any type of favoritism, any type of prejudice. The judge is saying, I know what happened in that secret meeting. So you guys are fine. Y'all don't have to worry about that. What does the statute say? It's not about what the judge thinks is fine. It's about what an objective, reasonable person would think. What do you guys think? Do you think it shows bias or favoritism or prejudice or partiality for the judge and the district attorney to gang up on Lil Whitty and coerce him to testify?
It's crazy.
Do you think that's fair? The judge is saying, I was in the meeting, guys. You're making a mountain out of a molehill. Maybe the details will come out. Don't worry about it. What you need to worry about is getting me the name of the person who disclosed the secret meeting. I want a name. Judge Glanville wants the name of the person who told he wanted to keep this secret meeting what? Secret. Somebody in the meeting spilled the beans. The judge suspects it is Little Woody's attorney, Miss
Bumpkiss.
Bumpkiss.
Yeah. Am I saying it right?
Interesting. So the judge is saying, guys, I was there. Don't worry about it. Everything's fine. It'll come out in the end. The statute doesn't say that. It's not what you think, Judge. It's what a reasonable person in the chat would think. All right. We're using the chat standard.
Mm-hmm.
Furthermore, Judge Glanville should not have coerced little Woody to testify. The law says that a trial judge should not attempt to intimidate a witness to testify on behalf of the state, either in or out of the presence of the jury. Well, goddamn. This sounds exactly like what Judge Glanville did. Right? The law says, I mean, it can't really be any clearer, guys. The law says a trial judge should not attempt to intimidate a witness to testify on behalf of the state. What the hell?
He
the
did.
Judge was like, I'll lock you up for years. Just go on and testify. That is intimidation and coercion. And here's the thing. Here is the thing. The judge was not trying to get little Woody to testify for young Thug. The judge was not trying to get little Woody to testify for Shannon Stillwell. The judge was not trying to get little Woody to testify for Demise. The judge was trying to get little Woody to testify for the state, for the prosecution. Yes. Yes.
If anybody's supposed to be impartial, he is. So you have favoritism on the prosecutor side. You have coercion of a witness. You have keeping this away from the defense attorneys. Like there's probably like at least 6 issues with what he did.
100%. You are so right, AV.
And we're not even halfway through this document yet.
Because this is crazy. Somebody, who sent this to me? Shout out to Sarah. Somebody write Sarah in the damn chat. God damn. This is
what time
crazy.
did she send it?
Sarah sent this to me at 4:49.
Wow. Yeah. Because it shows that it was filed at 3.
You guys are on it, man. Y'all are game. All right. Y'all are some detectives in here. All right. Let's keep going. So again, what does it say? A trial judge should not attempt to intimidate a witness to testify on behalf of the state. This is exactly what they did. As the Georgia Supreme Court wrote, we need not decide whether such bias or impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might be reasonably questioned, including instances where the judge's behavior could indicate that he or she has a personal bias or prejudice concerning a party or a party's lawyer. What are they saying right here? We don't have to show, Judge, that you actually are biased. We don't have to show that you lack impartiality. We just have to show that it seems like your impartiality might be reasonably questioned. We just have to show that, there's an odor of mendacity. There's an odor. I don't see anything, but I smell it. Right? We don't have to prove it. We just have to show that. What's that?
Go ahead. Finish that thought. Sorry.
No, go ahead.
No, I was just thinking about when he denied this motion.
Mm-hmm.
He hardly let the attorney get this out, right? He kept cutting him off, and he said, oh, it's about a ruling. You can't just, what you're supposed to do is if you just disagree with the ruling that I made, that's when I need to recuse myself. Right. So that thought just came to mind, because now that we're analyzing the document ourselves, we actually see that this attorney had word for word verbatim, not word for word, but at least what actually happened in that secret meeting. Glanville didn't let him get any of this out.
You're exactly right. Glanville did not want, because what happens, guys, in a courtroom, there's a little white lady, and what she's doing, she's taking down everything. And Glanville did not want that attorney talking. And just like AV said, every time that attorney opened his mouth, Glanville was like, oh. And the attorneys were like, well, oh. And then the attorney, well, what about, oh.
And he told him to be very careful.
Yes. Glanville did not want the white lady taking down what the attorney was saying. Glanville wanted to silence that attorney. He did not want that attorney to be allowed to make a record. Right? This is terrible. Let's keep it going. Defendants were not provided notice of the hearing either before, during, or after. And regardless, this is the thing, regardless, defendants should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of trial is being coerced to testify. The only logical conclusion to be drawn by the willful exclusion of all defense counsel from the secret meeting that contained Chief Judge Glanville, the state, and Little Woody, was to harass and intimidate Little Woody into testifying. You know what's interesting here? They're not mentioning Little Woody's attorney. Because
They're not. But
Woody,
I wonder if that's in the affidavit. Did Sarah send you the affidavit too?
I don't know. We'll take a look at it.
Okay.
Given the facts as alleged, given that the facts as alleged must be assumed to be true, the Weinstein affidavit is sufficient, and that recusal would be authorized under the alleged facts. Another judge should be assigned to hear this motion to recuse. Wherefore, Mr. Kendrick respectfully submits that the present motion meets all requirements, and this motion should be assigned to another judge for consideration. In the alternative, should this court deny the requested relief in this motion to recuse, Mr. Kendrick requests that this court make specific factual findings and submits that Judge Glanville should voluntarily recuse himself. Should the court take neither of the above actions, Mr. Kendrick moves this court for a mistrial.
Woo!
Due to the ongoing bias of the court as evidenced in the Weinstein affidavit, and on the basis that Mr. Kendrick is not receiving a fair trial as his constitutional right of due process and under the Sixth Amendment. Should all of the above requested relief be denied, Mr. Kendrick requests a certificate of immediate review. What is a certificate of immediate review? It allows you to file an interlocutory appeal. What is an interlocutory appeal? Guys, usually when you appeal anything in a trial, you have to wait to the end. But in Georgia, we have a process, and really in most states, in different states call it different things. But in Georgia, we call it an interlocutory appeal, where you don't have to wait until the end of trial. You can appeal something in the middle of trial. What's the problem? The problem is that the judge has to give you permission, and that permission is called a certificate of immediate review. When the attorney was standing up in court talking about this motion, he said, "Judge, I filed this motion." Judge was like, we ain't gonna do nothing with the motion. The attorney finally was like, "Fine, give me a certificate of immediate review. Let me appeal this now." The judge was like, "Ninja, you crazy. You crazy. I ain't giving you shit."
He said it's denied, and you can wait to the end of this case to file an appeal.
AV is so right. The judge said you could wait to the end of the case. What's the problem at the end of the case? It's probably going to be fall or winter of 2025. Look at all the bias. Look at all the prejudice. Look at all the corruption. This is insanity. Signed this day. Is it the 12th? This was today. Today, Douglas Weinstein. All right.
On Thursday, Brian Steele made serious accusations against the prosecution, alleging witness coercion and requesting a mistrial. This added a layer of complexity to the ongoing legal battle.
I would like the court to look into the appropriateness. Mr. Copeland, to my observations around your courtroom, outside your courtroom, embrace, is surrounded by several members of law enforcement with the district attorney's office and prosecutors, potentially other persons. I don't know why a sitting witness under oath is in a room with prosecutors during breaks, mornings, afternoons. It's totally inappropriate. There are people who are in your court's door. There's a double door where the court sits to its right that aligns with the witness chair. And I noticed people standing there in law enforcement while Mr. Copeland is testifying. He's making eye contact with them. I don't know if they're his brother. My point to you is this: what gives anybody the right to surround a witness? He's not in custody. And bring a witness. I'm sure Mr. Copeland didn't say to the prosecutors, I don't know this, Your Honor. So if you think I'm wrong, then just strike it from your memory. But I'm sure he didn't say, hey, you guys want to hang out in this room a little while? So I believe that he is being led on a tether by the prosecutors, and it is coercion. It is inappropriate. And why would anybody not be recording everything he said? And why do I have to get it in drips and drabs? So I am objecting to the tactics of the Fulton County District Attorney's Office and whomever else they may have employed with a citizen, regardless of what the court may think of him, what the prosecutors think.
I don't have any thoughts. So please don't put that in. Please don't put that in the ether. Okay, but that's what you just said, sir.
Ether is
okay.
Clear. The court wouldn't do it. I wouldn't do it either. So why is it happening?
I have no interest other than I'm a referee.
Well, you're the referee who spoke with the witness without my presence.
Mr. Steele, we're not gonna get it.
Let's stop it right there now. Let's stop it right there now. All right. And you know Brian Steele is feeling real good because the Supreme Court just let him off the hook. And you know that Judge Glanville is very embarrassed. He's so embarrassed because he was so angry, so furious at Brian Steele that he ordered him to be incarcerated for 20 days, 10 weeks in jail, every weekend through the summer. And the Supreme Court yesterday was like, no, Glanville, what the hell you doing? What the hell you doing? So now today, Brian Steele comes in and like, hey now, motherfucker, all right. Ooh, I like that little shot. Shout out to Brian. Let's go.
Employed with a citizen, regardless of what the court may think of him, what the prosecutors think.
I don't have any thoughts. So please don't put that in. Please don't put that in the ether. Okay, but that's what you just said, sir.
Ether is
okay.
Clear. The court wouldn't do it. I wouldn't do it either. So why is it happening?
I have no interest other than I'm a referee.
Well, you're the referee who spoke with the witness without my presence.
Mr. Steele, we're not gonna get into that right now.
Well,
okay?
my point is, how is he being treated here? And why don't I have all this? And why is this going on? What an unfair trial for Mr. Williams. Think about it. If you were accused, Your Honor, and the judge met with this witness, with the prosecutor, and you sat next to me and Mr. Adams, you would say to us, what kind of case is this? Now he's being surrounded with all this law enforcement. My point is,
Your Honor, we're going to object that this.
I'm not going to be interrupted.
Mr. Steele, hold on. But you're Mr. Steele? Mr. Steele?
Yes, sir. What?
Okay.
I want to finish. I'm making a record for the court to understand.
Well, Mr. Steele.
Wow.
I've never been interrupted in a court except for this one. You
but the challenges in this point in time is that some of the things that you have said at certain points in time are not appropriate.
It's not true.
Okay, well that's the court's.
Court is wrong.
Well, you have, everybody has an opinion, and it can certainly be reviewed at the appropriate time. But finish up so you can go ahead and make your record.
Interrupt anyone about a prosecutor or anyone. This is a record. This is important.
Okay, but it's your allegation and assertion, sir. Okay, so. Well, we don't know that. We don't know whether or not they're true.
What's going on? Every time Mr. Copeland comes in the courtroom or out of court, he's escorted by a DA's office investigator. You see that? This court is observant. You're not just sitting there in a cloud. You see exactly what's going on. You hear the prosecutor tell you, we were in a room with Mr. Copeland and he said, why?
Okay.
Why do I have to bring it up? You should be bringing it up. This is crazy. This is like communist Russia. Mr. Williams is having the worst trial. So I'm moving again to stop intimidating the witness by the prosecution, leave people alone, and stop accusing. You've allowed the prosecutor Love to accuse me of misconduct.
Oh, but you've also accused her of hold on. You have accused her of misconduct as well. And remember what I told you about your professional remember what I told you about your, and she's going to take me down as opposed to you. So when I start talking, stop talking, please. Okay? I'll let you complete your record. Okay?
I understand the one party talking. I got it.
All right. Okay. All right. So I told you, several times before, I told you and your colleagues, remember your professional responsibility and let's not make this an ad hominem issue. I don't believe that either one of you are trying to do anything that would subvert your ability to practice law. So, but
Love has intentionally lied to the court numerous cases. You do not.
Hold on. Let him finish. See, this is Mr. Steele. This is exactly what I'm saying. You cannot, it is not a good idea to state that your brethren across the bar are lying, okay? In any time or any way.
I don't like doing it.
Okay, but don't. So don't. But don't because you don't have any proof. If you have proof of it, then do you have proof? There's a mechanism in law and under the rules for you to submit that question to the Office of General Counsel and for an investigation to occur. But please stop, both of you. I told both of you earlier, stop making these ad hominem attacks toward one another. Okay?
Everyone gets attacked. You say nothing.
Well, okay, but I've said something. You're going back to stuff that's happened in the past. So while I'm trying to deal with things that are current. So I told you all most recently, as of about a week or so ago, to stop all this. Remember I told you the world's watching you? They are. So please don't from this point on, do not accuse each other of anything. If you want to go ahead and do it, there's a proper way to do it, but don't bring it up in front of me. Okay?
I'm just making a point that this has been going on and it's abusive. That is my point.
That's your assertion, sir, as a lawyer, okay? And maybe your frustration with everything. Like I told you, this trial's gone on a long time. There's a lot of wear and tear, but everybody's got to rise above and be a professional advocate. That's what the system demands of you.
I'm not worn or torn. I am here to tell the court that from a objective, casual observer, could see what's going on here is inappropriate.
Okay. At the end of the day, I understand your concern that you have now shared with the court. Okay. All right. State, do you want to respond?
Hell yes. You know,
Your Honor, I just ask that the court strike the portions of Mr. Steele's, whatever that was, to the court regarding personal and ad hominem attacks on members of the state's team. Ms. Hilton will address the merits of the initial argument that Mr. Steele made. But as to personal attacks on members of the state's team, we'd ask that assertions that specific people have lied, that is disrespectful, that is unprofessional, and not one time has any such statement been made by any member of this team about anyone else.
Oh, I think, Ms. Love, in the past, you've made some
I
statements.
have never said anyone lied.
You made some statements about Mr. Steele.
Ooh,
and
no,
about, well, just let me finish. I'm not done.
Shout out to Terica. Thank you for
All right, and about several others of your colleagues. I mean, and it may have been the heat of discussion and everything else. Like I said earlier, there's enough blame to go around for everybody. All right. So, but can we kind of stop that and draw things kind of forward? I've had 2 or 3 conversations with everyone about their obligations as professional advocates under the rules. Okay. And that while the court certainly agrees that ad hominem attacks they don't make anybody look any good. They really don't. I mean, but I'm just saying I acknowledge that. I acknowledge what's been gone on in the past. And I ask that you all reflect upon that because, like I said, you can't say some of the stuff that people say to one another can't be taken back. They just can't. And that's just something that the court would just have you reflect upon.
Thank you, Judge.
Sides, okay?
And we just ask again that statements like Miss Love lied be stricken from the record. Those are personal attacks. There's none been made, at least not this day.
I'm not gonna consider your ad hominem attacks. Either one is. Okay.
Thank you.
Or anybody's. All right. Okay. All right. Madam.
Here come Miss Hyde. Miss Hill.
Your Honor, regarding Mr. Steele's assertions of our interactions with Mr. Copeland, we have not treated Mr. Copeland any different than we would treat any of our other witnesses in the state of Georgia. He is our witness. If he wants to be around us, he can. If he chooses not to, he doesn't have to be. The fact that he's saying we are coercing Mr. Copeland to speak is clearly not true given Mr. Copeland's testimony here today. If we were coercing him to speak, he would answer my questions and I would not have to sit here and go in a back and forth and struggle with him. So clearly we are not being influential on Mr. Copeland given our interactions with him outside of the courtroom. So again, Your Honor, there's nothing inappropriate about the state's interactions with Mr. Copeland. He is the state's witness. We can't interact. We have not influenced any of his testimony, Your Honor. And so we ask that, I don't know if it was a motion, be denied if that was what was being asked of the court.
All right. I'll include the state's exhibit 400, the statements of the most recent email that you have disclosed to the defense in this case, for purposes of the record. And I will also, to the extent that I don't think of Mr. Steele, let me just make sure. Are you again moving for mistrial, or did you make them within your statement? Did you ask the court for a mistrial?
Yes, based upon totality of what I said. Yes.
Okay, I'm going to deny that motion, and I will also note for the record that it was that the saying was positive for the next question. Okay. All right, Mr. Matthews, you're eating up your lunch. Okay, so.
I just want to put on the record that based upon my vantage point in the courtroom, I have a unique place where I'm able to see the jury, I'm able to see the witness, and I'm also able to see the vestibule out here. And on yesterday, I just want to be clear that not only observe back here, but I have a unique place, and I observe a very large individual standing outside of that door, those two doors, staring at the witness during this testimony.
I know it's a large individual too. There's plenty of large individuals. They're law enforcement, or we don't know, but I know it's law enforcement. Well, who is it? What's their name? Okay, well then we don't know it's law enforcement. But I have the same or better vantage. I have the same or better vantage than you do, and I certainly, think that for reasons that we don't know, that law enforcement stand in that door for security posture, and that's the only reason that they're at that door.
Well, I understand. I'm just putting on the record.
Okay, well, when this is reviewed, and the court's going to look at what the court saw as well. So if you're thinking that there's intimidation or otherwise, I'm telling you, and I'm putting on the record for purposes of the record, that there are many law enforcement that sit in both doors of this courtroom for that reason and that reason only. And unless you can tell me who specifically was standing out there, as you say, and Ms. Shields said, looking at our witness, Mr. Copeland, then I don't see that. Okay? Thank you, sir.
Thank you, Judge.
All right.
Briefly, Your Honor, since no one wants to go to lunch with me, I saw the same thing that Mr. Matthews saw yesterday. a large individual.
How did you see him? Your back's to the door.
Are you questioning whether I saw him or not?
I'm asking how you saw it.
Oh my God.
Okay. All right.
Because that we've seen people outside that door for 18 months, Your Honor. This person yesterday was glaring through that glass for at least 10 to 15 minutes, and I noticed boring a hole into the witness. So I just want to add that is what I saw. I don't know his name. I don't know if it was law enforcement. I believe it was. I've not seen any other individual with law enforcement do that to that witness or any other witness during the course of the trial.
Okay.
Thank you.
Thank you.
Your Honor, this, just so that the record is clear, could they give more detail? Because there's no member of the state that fits that.
Yeah, I don't need.
And I
He
have
was
no
a
idea
gentleman
what
yesterday
it is.
dressed in black or dark clothing. That's what I saw.
Also, yes, Your Honor, and I don't know.
He's like, Woody is getting stalked by some huge man dressed in black, staring at him for 10, 15, 20 minutes at a time. Someone is posted up at the door, maybe intimidating little Woody, and no one knows who he is.
We don't know, one, who they're talking about, what they're talking about. Literally no idea. So the idea, this insertion into the record of the insinuation that someone is intimidating anyone.
I'll also ask Captain Kendall to ensure that only law enforcement are allowed back there in the vestibule, so that that if there's any issue with anybody looking in the courtroom, that is removed. So, all right.
Thank you.
All right.
This is an easy one. And I don't know whether this is something that the court can give an instruction in regards to. I want the folks to just take notice of it. We've had some discussions before about the configuration of the courtroom. There's a lot of folks in here. We've got jurors who are sitting right there on the front row who are closer than they would normally be to the parties in this case. I've noticed over the course of the last number of weeks and months, quite frankly, and I'd like the court to either remind the state or maybe because it could be inadvertent, but maybe they can take note themselves of the fact that sometimes their facial expressions, their reactions, their statements to each other, their conversations to each other are done so close in the presence of the jury that it can't help but impact the jury. There was one time last week where Ms. Hilton was attempting to introduce a document and there was some frustration because there's an objection, and Ms. Love reached over and says, and I could hear it from over there, just show them the original. Just show them the original. Mm-hmm. And you know, those type of conversations and you know, when someone's upset with a ruling and roll their eyes or makes a facial expression or throws up their hands in front of the jury, 2 or 3 feet away from the jury, can't help but impact the jury. And so if the court needs to just remind the parties that we've got a jury that can be impacted and they need to be a little bit more circumspect, they can do that. Or perhaps my colleagues across the aisle can take note of that themselves and act accordingly.
All right, sir. Yeah, there's not a lot of room, and I wish you'd have brought this up earlier, but I certainly agree with that. I'd advise all counsel to just be mindful of their reactions as the jurors watch everything. Okay. All right.
Apparently, the attorney just went in to help cover. Apparently, the attorney is a personal injury attorney.
Stop, really?
Yeah, it's not even like
she doesn't even practice criminal law.
She was just doing it to cover. And this happens to us, guys. This happens to us. We get set up sometimes. So, like, let's say AV she's an attorney and she does workers' comp. And let's say I do divorce. And so she does workers' comp and I do divorce. And I say, hey, AV, listen, I got to go to another courthouse, but I need you just to cover this small little hearing. All you have to do is just go in, say yes, 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 and sign the papers. That's it. I got it all worked out. I talked to opposing counsel, talked to the judge, let everybody know. You just go in. I need you to go in, just say yes to a few questions and then sign the papers. Everything's fine. So then AV says, fine, I'll help you. She goes, she shows up to court. Everybody's there. The judge looks at AV and says, okay, AV, are you ready for trial? And if you like,
Whose trial?
exactly. I was supposed to sign something.
What you mean?
Like, what you mean?
Of course, there were more Woody shenanigans where he admits to lying on the stand and had an interesting interaction with the court reporter.
It never crossed my mind.
So how were you able to tell Detective Gaither that Nut and Thug was cool?
Because they're questioning me and I'm trying to get them off of me. And she asked me questions about Nut and Thug, I guess. And I'm telling her whatever she asked me, let's say she asked me a question about the sky. I'm gonna say, yeah, I seen the sky. It's blue. Whatever she asked me, I'm gonna agree to that. I'm gonna say whatever she asked me. If she asked me about this reporter right here, I'm gonna say, yep, she's sitting outside me with white tennis shoes on. I'm gonna say something. Just because I want her to believe I'm telling the truth. That I want her to get me out of jail.
What, she has on white tennis shoes, don't she?
Don't you got on white tennis shoes?
Oh my God.
Oh my God.
She got on Chucks.
Right, and they white, right?
She had on Chucks.
Got on Chucks.
So you telling the truth.
What color your shoes is? She said they white.
So you're telling the truth then.
Well, it depends. See, you pick what you want to tell them.
So did you also tell Gaither in another interview that Nut and Thug had problems?
Can you say it again?
Did you also tell Gaither in another interview that Nut and Thug had problems?
See? You saying it right then and there.
So my question for you is, how would you be aware, how did you know about any relationship between Nut and Thug?
I didn't.
Friday was a shorter day, which really consisted of more direct examination of Woody. We can expect to see more direct examination of Woody on the witness stand next week, but we can also expect cross-examination by the defense attorneys. These developments have added a new level of intensity to the trial, with accusations of improper conduct and legal maneuvering coming to the forefront. The defense and the prosecution are locked in a heated battle, with both sides facing significant challenges.
When your car got shot at, did you know about Lucci's mother's home being shot at?
What you mean?
Were you aware that Lucci's mother's home was shot at?
Huh?
When you met with Detective Gaither,
right,
about what happened on the highway, during that time period, were you aware of Lucci's mother's home being shot at?
No.
Do you recall talking to Detective Gaither in that January 28th interview about Lucci's home being shot at?
I can't recall.
During that interview, do you remember telling Detective Gaither and Detective Dennis that Lucci's mama and dad got shot? So Nick called Big Boo's phone, and we was at Big Boo's house. Do you recall telling them that?
I don't recall.
Let me ask you this. Do you recall independently being with Big Boo and Lucci's manager calling his house, calling his phone, trying to give him $20,000 to find out whoever shot up Lucci's mama's house?
I'll stay in the form. You can rephrase.
Do you recall being at Big Boo's house and someone from Lucci's manager calling Big Boo back in 2015?
I don't recall.
As the trial continues, we'll keep you updated with the latest news and insights. Hit the notification bell so you don't miss any updates. Stay safe out there. See you in the next one. Bye.